So we got Chapter 15 Mortgage Law. It's also Lesson 11. And let's go. Question 17. Which of the following contractual clauses in a mortgage could apply where a borrower defaults? And the answer is 4. All of the above clauses would apply. 1. The omnibus. 2. A mortgage in possession clause. And 3. An acceleration clause. All those could apply when somebody who borrows money defaults. All the above. 32. Which of the following correctly completes the phrase a mortgage is? And our answer is 2. Only A, B, and C correctly complete the phrase. So A, a mortgage is a contract. B, a mortgage is is an evidence of a loan. C, a mortgage is security for a loan. Okay? Now, this is false. D, required to be registered to be effective between the parties. So that's false for a definition. So we've got number 2, A, B, and C. Correctly complete the phrase. A mortgage is a contract, evidence of a loan, and security for a loan. Question 50. In BC, a lender who holds a mortgage registered as a charge on an otherwise clear title to a borrower's land has, and the answer is 2, an interest in land created by contract. A lender who holds a mortgage registered as a charge on an otherwise clear title to a borrower's land has 2, an interest in land created by contract. And I just want to explain about 51 here. It says the first registered mortgage is a legal mortgage, while any subsequently registered mortgages will be an equitable mortgage. So remember that? Where's my pen here? You got an equitable mortgage if it's a second mortgage, all right? Or third mortgage. Charging the borrower's equity of redemption. Okay. An assignment of a first mortgage is done by the lender to a third party, who then is entitled to enforce the lender's rights directly against the borrower. Question 95 on page 3. The transfer by the borrower of the equity of redemption to a subsequent buyer does not always relieve the borrower of the covenant to repay the debt. However, there are circumstances where the borrower may be relieved of liability on the personal covenant. Which of the following events would not relieve the borrower from this liability? And the answer is 2. The borrower has sold the property with the knowledge of the lender. So this would not relieve the borrower from the liability. The borrower has sold the property without the knowledge of the lender. But these other things would relieve the borrower from the liability of on the personal covenant. 1, received a release from the lender. 3, the Property Law Act releases the borrower. And 4, lenders become disabled from storing the property unimpaired. Okay, those things are all could relieve the borrower from liability, but not 2, the borrower has sold the property with the knowledge of the lender. Question 121. After a borrower has given a mortgage of real property, the borrower's remaining interest is described at law as 3, the equity of redemption. So if you have received a mortgage, then your remaining interest is called the number 3, the equity of redemption. 122. In a mortgage contract, the promise by the borrower, why is it so hard for me? In a mortgage contract, the promise by the borrower to pay the installments of principal and interest as they fall due entitles the lender to exercise the remedy of an ordinary creditor separately from a foreclosure application in case of default. This promise is known as 2, the personal covenant. So the personal covenant, it is the answer 2, and it's a promise. And it's a promise. The personal covenant is a promise where the borrower promises to pay the installments of principal and interest as they fall due. And because of that, the lender can exercise the remedy of an ordinary creditor because of the personal covenant. Page 4, 136. A lender who is foreclosing may ask the court to appoint a receiver where the property being foreclosed is, and the answer is 4, any one of the above. And these things are number 1. So this is a lender who's foreclosing may ask the court to appoint a receiver when the property being foreclosed is number 1, a large residential apartment building. Number 2, a single family dwelling with a tenant occupying it. And 3, a single family dwelling abandoned by the borrower. All right. So the answer is 4, any one of the above. Now, who is this mysterious receiver? And I'm going to put a little note here so I can check this out when I'm doing my further studies. Question 182. An option to purchase the mortgage property given by the borrower to the lender at the time the mortgage is negotiated is void. 2, void. An option to purchase the mortgage property given by the borrower to the lender at the time of the mortgage is negotiated is number 2, void. 184. After an order nisi of foreclosure is granted to a petitioner and the respondent borrower fails to pay the amount due as required by the order, the petitioner may apply for 184 for either 1 or 2. Either 1, an order absolute of foreclosure, or 2, a judicial sale. All right? So either 1, an order absolute of foreclosure, or number 2, a judicial sale. This is during a foreclosure. All right? Question 200. After the contractual right to redeem has passed on a mortgage, all right? After the contractual right to redeem has passed on a mortgage, then 3, an equitable right to redeem still exists. So you've got the contractual right to redeem. Once that's passed, 3, an equitable right to redeem, it still exists. Isn't that great? Page 5, 234. Which of the following is not an implied term of a mortgage? And the answer is 3. The borrower is entitled to assign the mortgage. This is not an implied term. 3. The borrower is entitled to assign the mortgage. No. But these other things are implied. 1. The borrower is entitled to redeem the mortgage within a reasonable time. 2. The borrower is entitled to redeem the mortgage free from all conditions or terms of the mortgage contract. And 4, the borrower is freed from any unreasonable collateral advantage required by the lender, and nothing unreasonable. Okay. And the answer, just wait, I'm screwed up here again. Oh yeah, the answer is 3. The borrower is entitled to assign the mortgage. No. You cannot assign the mortgage, you fucking idiot. All right? You can't assign the mortgage. It's not implied. 251. Any clause contained in a mortgage which clogs the equity of redemption is called a clogger. 251. The answer is 2. Void. Any clause that clogs an equity of redemption is 2. Void. 252. A quitclaim deed. A quitclaim deed is, number 1, terminates a borrower's interest in a property in favor of a lender. So a quitclaim deed, 1, terminates a borrower's interest in a property in favor of a lender. So if you do the quitclaim deed, you got that? 391. A term of the mortgage provides that the full outstanding balance will be due and payable in the event of default by the borrower in making any payment. I mean, if you're going to default on your payments, where are you going to get the money for your outstanding balance, the full outstanding balance? I guess I'll find out how creative people are. This term is known as 391 for the acceleration clause. So the acceleration clause, it means that you got the full outstanding balance due and payable in case the borrower defaults. Page 6. 393. Alexander Management Company Limited has just arranged a $1,450,000 mortgage loan to finance their purchase of a small retail shopping complex. The interest rate is 12.75% per year, compounded semi-annually. So it's J2. The amortization period is 20 years, and the term of the loan is 10 years. Payments are to be made quarterly and rounded up to the next highest dollar. Which of the following statements is false with regard to this contract? And the answer is 3. Under the terms of the Canada Interest Act, the total outstanding balance on this loan can be prepaid at any time after 5 years from the initiation date of the mortgage. That's false. Why is it false? I'm guessing because it is the terms of it's the Canada Interest Act. Doesn't really deal with that. These other things are true. The quarterly payments will be $49,701. The outstanding balance, this too, at the end of the term will be less than $1,123,500, but we haven't really calculated, have we, Vinny? 4. The lender has no right to demand payment of the total outstanding balance at any time prior to the end of the contractual term, provided the borrower meets all contractual obligations. That's true. But the one that's false, and this is our answer, is under the terms of the Canada Interest Act, the total OSB on this loan can be prepaid at any time after 5 years from the initiation date of the mortgage. All right. It's not the Canada Interest Act that deals with that. 406. A contract between a seller and a buyer whereby the seller agrees to sell its interest in certain property to the buyer for a price payable by installments and then to convey legal title to the buyer after payment of the purchase price in the manner agreed is called a 406. Number 4, an agreement for sale. Agreement for sale is a contract. It's between two parties, a seller and a buyer. And the seller here agrees to sell his or her interest in certain property to the buyer. For how much? For a price payable by installments. And then to convey legal title to the buyer after payment of the purchase price in the manner agreed. It's called an agreement for sale. 433. Under the BC land title system, a mortgage is registered as a charge against the property of which the mortgagor is 433. 3. The registered owner. Under the BC land title system, a mortgage is registered as a charge against the property of which the mortgagor is, and the answer is 3. The registered owner. The registered owner. Mortgage is registered as a charge against property. All right, you've got to be the registered owner. All right? 464. Which of the following is the example of an equitable mortgage? And the answer is 4. All of the above. 1. Mortgage of the equity of redemption. 2. Agreement to execute a legal mortgage. And 3. A mortgage by way of deposit of the duplicate certificate of the title. So typically an equitable mortgage, that's second or third or whatever mortgage. And all these things are true. Number 4. It's the mortgage of the equity of redemption on your first mortgage, I think, right? And then you agree to execute a legal mortgage. And 3, you mortgage by way you deposit your duplicate certificate of title. These are different ways to get the job done. Page 7, 478. A court has power to reopen a mortgage transaction where, having regard to the risk and to all the circumstances, it is of the opinion that the cost of borrowing is excessive or harsh and unconscionable. In which of the following statutes is this power contained? What power? What power? Oh, the court's power to reopen a mortgage transaction. Where is this statute found where a court can reopen a mortgage transaction. When they find out the cost of borrowing might be sky high, too high. So we find that in number 4, the Consumer Protection Act. Consumer Protection Act empowers the court to reopen a mortgage transaction and to investigate. Question 500. Which of the one of the following is not a provision of the Interest Act? And the answer is 1. No interest rate higher than 25% shall be provided for in a mortgage document. That is not a part of the Interest Act. No interest rate higher than 25%. No. 2. Where a mortgage requires blended payments of principal and interest, the mortgage document must contain a statement of the interest rate calculated yearly or half-yearly, not in advance. Okay, so that is in the Interest Act. 3 is also in the Interest Act. If a mortgage document calls for interest without specifying the rate, then the rate defaults to 5% per year. Right? If they don't mention the rate, it goes to 5% per year. 4, this is also in the Interest Act. The interest rate on arrears under a mortgage may not exceed the rate payable on the principal monies not in arrears. Okay, so you can't have 2 mortgage rates. So those things are all in the Act, but not the thing of number 1, no interest rate higher than 25% shall be provided for in a mortgage document. No. 510, an option to purchase the mortgaged property given by the mortgagor to the mortgagee at the time the mortgage is negotiated is 510. What do you call this option to purchase? It's called 2, void. It's void. What's void? Option to purchase a mortgage property given by the mortgagor to the mortgagee at the time the mortgage is negotiated. The option to purchase is void. Interesting. 516, where a borrower believes that the amount of interest being charged is excessive, under which statute might relief be granted? And 516, the answer is 2, the Business Practices and Consumer Protection Act. So if you think you're being charged too much interest, you could go to the Business Practices and Consumer Protection Act and see what's going on there.